all conferred, and I think we all have a non-meeting of the minds. We all disagree on our positions. The state's position is that an offer was conveyed with a set deadline that a plea needed to be accepted, and that plea was not accepted. From the state's understanding is that the defendant is saying he didn't reject that offer, he just wanted a different offer. The state's position is, since he wanted a different offer, which was lower than the state's offer, the state views that as, well, the offer was rejected then, because the state wasn't willing to go lower than that offer. It wasn't accepted, the bargaining time ended, and so here we are. And the state has made a new offer, conveyed that offer to defense, and that's where we are.
Judge, and it's our position that he never rejected the offer. The state, when we were in here, the judge gave us the 24th of January, it's his trial date, and at that time, we either accept it or reject it. If we reject it, we would start trial. However, Ms. Harrington said that she personally wanted an answer by January the 4th, whether he accepted the offer or did not accept the offer. Mr. Jones and I went and I talked to him, asked him about the offer. He never rejected the offer. The exact quote was, "I am not rejecting the offer, I am rejecting you." I contacted Ms. Harrington via text message and said that he is not rejecting the offer, that he's rejecting me. She texted back saying that, oh, so he is rejecting the offer. And I said, no, he is not rejecting the offer, he is rejecting me. Therefore, we had Mr. Jones brought over yesterday to formally either accept or reject that offer on the record. Having said that, Your Honor, Mr. Jones did, in all candor, ask if we could ask for a lesser time. I've already asked for that lesser time. That was said no to, but as the court knows, even on a trial date, we still confer. So
well, what I can tell you all is one, I mean, if there is a written contract, then I can look at the written contract. But as far as me going behind plea negotiations, I really can't. What I can tell you all is that in the court's file, I set plea deadline dates. And the plea deadline date for this case was January 24th. So that's where we are. That's the court's plea deadline date. And I put January 24th as jury trial and plea deadline date. And the reason why I do that, so there's no confusion when people are saying, well, this is the deadline for my offer, unless people come to me and say, okay, Judge, we worked out a potential plea agreement. And even though your deadline is January 24th, we're only giving them to this time. Because if that was the case, and if it would have been presented to the court, I would have put in my file, no, your plea deadline date is not January 24th. It's whatever you all say.
And that was, Judge, presented to the court. It was said to the court, we made the court aware that at the time that we were before the court last time, there was a plea deadline date, and even Mr. Porter spoke up that I had set a deadline of January 4th that he would be speaking with Mr. Jones prior to that to find out if he was accepting our offer at that time. And he would be in touch with me because I had actually asked for a time earlier than that. He had asked for a little bit longer to get past the holidays. And I conceded and gave that time. And so he said he would check in and let me know on the 4th if he had accepted our offer. And Mr. Porter did check in with me on the 4th and let me know.
All right, so this is what we're going to do. We're going to put it on the record, and everybody can put their understanding on the record, not the actual plea offer, but if people want to put what was discussed as far as deadlines, you're more than welcome to do that. Court is going to call 2022 CR 8529 2021 CR 2489, 2020 CR 11654, 2020 CR 8810, that's a different one. All right, State of Texas versus Melvin Jones. Could I have parties announced for the record for the state,
Stacy Harrington.
for the defense?
Robert Porter.
And are you Mr. Jones?
Yes.
All right. So it's my understanding he has other pending cases, but Ms. Harrington, is your case the one that is the deciding factor in all the other cases?
To a degree, Judge.
All right. And which case is that, Ms. Harrington?
It's the promotion of prostitution.
All right. And so for the record, that is cause number 2020 CR 8810. So there is an issue with regards to plea negotiations. Is that correct?
Yes, Your Honor.
All right. So as I've said off the record, I don't want to know what the offer was, but there's some issue whether or not an offer was accepted or rejected. Is that correct?
That's correct, Judge.
All right. So states, you may proceed.
Thank you, Judge. When we were last here on December 19th, I believe it was,
Yes.
the parties conferred. A plea offer was made with a deadline on that offer. The state had asked to hear back on January 4th, whether or not that offer was accepted or rejected. That was agreed to. The parties both approached the bench and said that an offer had been conveyed. We received a setting of January 24th for a trial date plea deadline. And both parties made the court aware that the state had set an earlier plea deadline. And the defense would be speaking with Mr. Jones prior to the new setting date and would let the state know whether or not that offer had been accepted or rejected. It was the state's belief that on January 4th, if the offer had not been accepted, that offer would be considered rejected and that plea offer would no longer be valid and a new offer could be made or the case would proceed to trial.
All right. And so defense, before you give me your rendition, I just have one question. So with regards to the court setting a plea deadline of January 24th, do you agree with Ms. Harrington that a different plea deadline was decided between you both?
Yes, Judge, and everybody's on the same page as that. I'm looking at my notes from December 19th of 2022. Big letters I wrote down. Ms. Harrington, no, plea by January 4th, what his catch would be. So on January 4th, I did go to the jail. I spoke to Mr. Jones. I don't want to get into the renditions of that. It's attorney-client privilege. However, we did discuss the plea bargain. After heated exchanges, Mr. Jones looked me in the eye and said, I am not rejecting the offer. I am rejecting you. So based on that, I texted Mrs. Harrington and I said, he is not rejecting the offer. He is rejecting me. And the response was, so he's rejecting the offer. And I said, no, he is not rejecting the offer. He's rejecting me. Therefore, we came to the court to put that on the record as of yesterday for him to either formally or informally either say yes or no, that I'm rejecting this offer and take it away from not it being about me, but about the offer itself. Ms. Harrington was not available yesterday, so he's here today. Now, as far as any kind of, will you ask for a different number or anything like that? That's normal course and practice for us, even on deadline dates. That's everybody's conferring at this point in time. Something may change or may not, but that doesn't mean I did not formally reject the original offer. So it's our position that that offer was never rejected, Judge. And now we're here before the courts this morning for what we do next.
Okay. All right. Any response to that, Ms. Harrington?
Yes, Judge. If he wants less time, it's back and forth. He could have asked me for less time that day, and I was told he wants less time that day, right? No, I'm sorry, he doesn't get less time. The back and forth happens, right? It's still, we're not going to go down. He's not going to take my offer. It's still considered rejected, right? And it wasn't taken. whatever the case may be, it wasn't taken, it's considered rejected.
Judge,
And so the state's position is the offer as it was not taken, is considered rejected.
again, things change at that time. Mr. Jones right now has a sickly uncle, and the reason that he was asking me to ask the state about that is because he was seeing, is there a chance that it could be a lesser number of years so that he may be there for his uncle, that he doesn't die on him while he's in prison, if that's gonna be the offer. And the attorney's gonna do what their client asks. That doesn't sit there and say, if they say no, then we go back and no, they're not. So do you accept the original offer or you don't?
All right. This is what the court is going to do. Ms. Harrington, I understand that you are in a jury trial.
Yes,
You
Judge.
probably need to get back there
I
quickly.
do, Judge. I'm sorry, my phone is blowing
No, no, no,
up
no, no. How long do you expect your trial will last?
all week.
All right, so what we're gonna do is, we're gonna recall this for next week. And the court will make a decision about contracts. Who knew I would be here doing contract work? Thank you, Professor Casterly of St. Mary's University. Although it's an oral contract and not written, so we'll see where this takes us. So I know your mind is probably with your jury trial, so go to your jury trial. And we're gonna come back next week. So you will not be in trial this week. Okay? All right, thank you, Ms.
Thank you,
Harrington.
Judge.
So, Ms. Ferguson, on this case, next week is a short week. Mr. Porter, when are you available next week?
Judge, as soon as possible, simply because the time deadline with the court also. And I need to be able to represent Mr. Jones to the best of my ability. And
No,
so
no,
I don't
no,
wanna judge-
here's the thing. I know it's set for jury trial on the 24th. We'll cross that bridge when we get to it, but I like to do things orderly and one step at a time. So the first thing that I want to do is figure out this
Well, is
plea or not.
are the courts open Monday or not?
No,
Then Tuesday.
because that's a celebration and everything that goes with it.
Well, I
It's a
was-
celebration and a holiday.
Well, I was confused because the court told me to show up on the 16th.
No, 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 no.
Till I got back to my office, I was thinking.
No, not on the 16th. Unless you're showing up to March with me.
So the 17th would be fine.
All right, so Ms. Ferguson, can we bring Mr. Jones back on the 17th? All right, we're going on the record. Court is calling 2022 CR 6643, State of Texas versus Karen Munoz. Could I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
John Young.
And are you Ms. Munoz? Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I believe I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Munoz, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Ms. Munoz, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance penalty group 1 gram to 4 grams? That's a third degree felony. The range of punishment is anywhere from 2 to 10 years in prison. Did you understand?
Yes, ma'am.
Did you understand if the state is able to prove the repeat offender enhancement allegation paragraph, then your range of punishment will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes,
Did you understand by entering this plea bargain agreement, you were giving up those rights?
yes,
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
yes.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she is and was.
All right, off the record for a moment. With regards to an interpreter, I'm going to take that case up right after this one. Thank you. We're back on the record. Ms. Munoz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
No.
Are you a U.S. citizen?
Yes.
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes. Yes.
According to the plea bargain agreement, punishment is to be assessed at 5 years in the prison. There's a $2,500 fine, no application for deferred adjudication. State recommends community supervision, and there is $57 for drug testing. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney?
Yes.
Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation and 180 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor. State offer, state exhibit number 1 with all of its attachments.
No objection, Your Honor.
Ms. Munoz, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments. I'm sorry, with regards to the repeat offender enhancement allegation, how do you plead to that? True or not true? I'm sorry. Did you say true?
Yes. Ma'am.
All right. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement allegation true based upon your plea of true and based upon states exhibits 1 and attachments. Are we proceeding with sentencing?
No, Your Honor, we're asking for a 45-day delay on the PSI.
All right, state.
States will defer to the court on the PSI. It is a agreed 5/5, Your Honor.
We told you earlier why we need a
Yes,
little bit more.
I understand that. If you want, we can go forward with sentencing. And then if there is an issue, the court still has jurisdiction.
And I would prefer, Your Honor, if we gave her some flexibility here before we impose sentence.
Okay. All right, we'll reset it for 30 days.
Thank you, Your Honor.
And the information that needs to be turned over, that needs to be done before that 30-day time
Thank you,
period.
Your Honor.
If not, then we will go forward with sentencing. What date?
I can do the 7th.
All right, we're coming back on February 7th at 9 a.m. And Ms. Ferguson will give you the reset form. No PSI. Ms. Munoz,
Yes, ma'am.
if you're drug tested today, what are the results going to be?
I'm not.
I'm sorry.
I said, no, I'm not doing.
Okay. All right, we'll see you back on February 7th. All right, this is a motion to revoke, correct?
Yes, Your Honor, but I was gonna approach the court to ask for a reset, a short reset. Because the main allegation on the MPR is the new number 1 DWI. And I'm in the process of trying to work that out. It might be worked out in his favor. That's why I did not want to proceed on it.
When is that going to be?
Well,
worked
he
out?
just went to court earlier this week. But now that I know that there's emergency on your MPR, I will push that to see if it's gonna work out in our favor, or if it's not, then I'll just pay them down.
So when is the misdemeanor reset for?
It said like a month out, because we just went to court earlier this week, but, I did get all my discovery already. And I'm gonna push it and see if I can, like I said, if for some reason I can get that thing dismissed, then this MTR becomes a lot less of a problem for him. But if it's not, I will be, forward with the, ADA and let him know, look, I'm just gonna plead him and then he can plead true that he just pled out.
So this is not going to be contested?
No, no, Judge. Because either we get a dismissal and then this, maybe this MTR goes away. And if not, if we don't get a dismissal, then I'm gonna plead him and we don't need to have it contested.
All right, Ms. Ferguson,
Yes, ma'am.
on Ernesto Dominguez, when is his misdemeanor case set? I don't have the misdemeanor cause number. But his SID is 11-36196.
February 10th.
Okay.
County Court 12.
It's 12. Okay. All right, Ms. Ferguson
Yes, ma'am.
and State, do you have any objections to a reset?
State doesn't have any objection.
All right, so this is what we'll do. We're gonna reset this, and we'll reset it for, Ms. Ferguson, can we put this on February 10th?
Yes, ma'am.
All right, we're gonna reset this for February 10th. And I'm gonna, order that he report weekly until his setting, because I see here there are some issues. I'm not accepting any of it is true, but the allegations are you're drinking alcohol, and that's not allowed on probation. And he's not doing his parenting classes, allegedly.
No, Judge, we had a conversation in my office regarding the drinking. And unfortunately, his response was, you know, no one ever told me that I wasn't supposed to do
Oh, I tell everybody that.
it. So I said, maybe you misunderstood. It's a condition or your probation, that you can drink or have any kind of drug.
All right, and why was he late for court?
Judge, he did call my office 2 or 3 times in the morning, and I was stuck on 81 because there was an accident. But he was in 187, and she doesn't read or write English. So he didn't know that he wasn't supposed to be over there because there's a sign on the door that says to come in.
Okay.
That was it.
All right, thank you. Yes,
His case expired in November on his current probation. So I can't amend the code for the weekly reporting, but if you give him instruction.
all right, you need to report to probation once a week until we hear this. And he's actually on probation out of this court for a misdemeanor.
That's correct, Judge. It's 2 years misdemeanor, and he was a month or so away from finishing.
Okay. All right, then, Ms. Ferguson will give you the reset form and we will see you then.
Thank you, Judge. May I be excused, Your Honor?
Yes. Court is calling 2022 CR 11032, State of Texas versus Michael Rios. Can I have parties announced for the record for the state? Defense,
Jerry Valdez Jr. from Mr. Rios.
and are you Mr. Rios?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor, may I have?
Court will find that the state is in compliance with discovery. Mr. Rios, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, it appears that you're proceeding on the indictment as presented. Is that correct?
Yes, sir.
Mr. Rios, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of theft under $2,500 enhanced? That's a state jail felony. The range of punishment is 180 days, up to 2 years in the state jail facility, and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yeah, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Your Honor, and he was.
Mr. Rios, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
The court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is asking that your punishment be assessed at 90 days in the Bexar County Jail under 1244 of the Penal Code. There's a $1,500 fine. There are no applications. The state will take in consideration cause number 2022 CR 11031. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
That is the agreement, Your Honor.
State?
Yes, sir.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's plea?
Yes, that state could admit within market state if it's one and attachment that does it.
No objections, Your Honor.
Mr. Rios, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney?
Yes, Your Honor.
Did you understand it?
Yes,
And
Your
did you sign it in all the appropriate places?
Honor. Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, we just ask the court to follow the agreement we have with the state.
All right, Mr. Rios, why do you continue to steal? This has got to stop.
Yes, yes, Your Honor. Yes, it is.
I mean, do you just steal because you like stealing?
No, it was a financial issue, but I'm gonna get back on the payroll.
Well, everybody has financial issues, but they don't resort to stealing. And sometimes people can understand if you're stealing food, but you're not. And because this is a theft enhanced case, this means this is the third time you've been stealing. So you're gonna have to start making a decision in your life. How old are you?
35.
All right, you're getting close to being in the twilight of your life like I am, where you have more of your life behind you than in front of you. And you're gonna have to make a decision. Do you want to spend the rest of your life in and out of jails, maybe Bexar County Jail? Or maybe spend the rest of your life in prison?
No,
That's
Your Honor.
completely up to you. And in prison, I don't think there's a lot to steal. Okay? Do you have children?
No, Your Honor.
Well, that's a good thing, because you need to get your life together before you try to bring another human being onto the planet, okay?
Yes, Your Honor.
All right, the court will follow your agreement, sentence you to 90 days in the Bexar County Jail under 1244. You credit for any time served. There's a $1,500 fine. Time and money will run concurrent. Take in consideration 2022 CR 11031. Is this a judgment satisfied?
Yes, Your Honor.
All right.
He's in custody since September the 15th.
All right, the court will show that the judgment is satisfied. Going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
That's true.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. And if you have a drug or alcohol problem, there are plenty of places that are free for you to go. All right? Good luck to you. State, can I get the dismissal?
Thank you, Your Honor.
You're welcome. Deputy, before you take him back, here's his dismissal. Court is calling 2022 CR 1618, State of Texas versus Omar Madison. Can I have parties announced for the record for the state,
Officer Sweet.
for the defense?
John Robertson for Mr. Madison.
And are you Mr. Madison? Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Madison, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
No, Judge, we're proceeding only on count two. Waiving any count.
Any objection?
No objection.
Mr. Madison, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand in count two, you're charged with the offense of injury to a disabled person, bodily injury as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? Okay, I'm gonna need you to speak up so that the court reporter can hear. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Madison, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count two. They're asking that your punishment be assessed at 2 years in the prison. There's a $1,000 fine. There are no applications, and there's to be no contact with Robert Cancillo, Cancillo. Did you understand that to be the plea?
Yes, sir.
Defense?
Yes, sir.
State?
Yes, sir.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there been any such motions?
No, ma'am.
Then to the offense as charged in the indictment and count two, how do you plead? Guilty, not guilty, or no contest? State any evidence to support the defendant's plea?
Yes, Judge. State offers us in Market States Exhibit 1 and its attachment. to that.
No objection.
Mr. Madison, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, Omar had a bad day that day. He wants to put this behind him and move forward. There's never any history of anything like that before, and I've gotten to know him a little bit. He's a good guy. And he just wants to get this going and serve his time and get it over with.
All right, this is what the court is going to do. The court is going to sentence you to 2 years in prison, give you credit for any time served. There's $1,000 fine, time and money to be concurrent. There's to be no contact with Robert Cancilio. And the defendant is not allowed employment as a home health care provider or with minors. Is there anything else from either side with regards to sentencing? I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Yes. All right, we can go off the record. So, Mr. Madison, here's the thing. Not everybody can be a doctor. Not everybody can be a healthcare provider or work with children, because those jobs requires a lot of patience. And it amazes me that people hire people to be home healthcare providers and work with children, and it's not something that that person ever meant to have as a career. I will tell you, when I was a defense attorney, everybody used to work at West Telemarketing, because that's where they were hiring everybody. And I think all the defense attorneys know, where's your client working? West Telemarketing. Then judges would say, no, I'm not allowing them to work at West Telemarketing anymore. I don't allow people to work as home healthcare providers, because to me, you really have to be called to do that, because when you're a home healthcare provider, somebody's vulnerable, they're sick, sometimes they need diapers changed, sometimes they act out, they have bad days because they have dementia or whatever it may be. That's just a profession you don't need to be in, okay? All right, good luck to you. Thank you. All right, Mr. Nichols. They are, I'm signing the commitment order. What was his bond set at on the, this case? All right, the bondsman is asking to be placed back on your bond. I'm being instructed that you haven't received your magistrate's warning. I'm going to sign the request to reinstate the bond with the bondsman, but I will give you your magistrate warnings. What I can tell you is I don't know anything about your case other than what you're charged with. Any questions about the facts of your case, you'll need to speak to your attorney about that. So you have a right to remain silent, a right to have an attorney appointed to your retained counsel. I note that Mr. Toshi is representing you. Mr. Toshi, are you appointed or retained?
I was appointed judge very recently, but appointed.
All right, so Mr. Toshi is your appointed counsel. If you decide to have an interview with anyone from the state or the police, you have a right to have your attorney present. Once you begin the interview, you can terminate the interview at any time, but anything you say can be used against you in another proceeding. If you're a foreign national, you have a right to have access to your consulate. With regards to the appointment of an attorney, they will determine whether or not you're indigent, which obviously they would determine you're indigent because you have an attorney present. Your attorney that is appointed to represent you will contact you by the next business day, but again, your attorney is present. Do you have any questions? All right, your bond is set at $3,000, which is what the previous bond was set at. I need you to sign this document stating that I've gone over your warnings with you. I'm sorry, one other final thing, you have a right to have an examining trial as well. Well, I've signed the motion to reinstate bond.
Okay.
So whatever needs to be placed in the system, that will be placed in the system. I've reset his bond for $3,000 because I noted that he was, it was due to the bondsman that surrendered, filed an affidavit to surrender surety. Today, Mr. Ferris. Your name always, I'm sorry, it's Paris Ferris. We are, so your parents named you Paris? Is that after the play, Shakespeare play, or is it after the city?
City,
Oh, okay. Your parents love Paris?
she wanted to go.
Ah, okay. Not Paris, Texas, though. Okay. All right, so today is the day where you make a decision on whether or not you're accepting the state's offer. Do you understand?
Yeah.
All right, and so your attorney is telling me that you're rejecting the offer. You're requesting a jury trial?
I said, I accepted, but I'm.
All right, let's do this. I'm gonna step out the room. So if you want to put the offer on the record for him, you can.
Okay.
And then I'll come back when you all come get me outside, okay? I don't have, oh, it's up next. All right, Mr. Dominguez, your attorney is not going to be here today. Your attorney has some health issues.
Yes.
So my understanding is that he's been in contact with you, so we can do one or two things. We can reset this case, in which case what will end up happening, we'll reset it and we'll see how your attorney is doing. And or either if you wish to have another attorney, we can do that as well.
The only thing that I knew about him is that this case was supposed to be for a bond reduction today.
Well, I mean, we're not going to do a bond reduction today because your attorney is not available.
I'm not sure what to do. I mean, I don't know anything of him. I knew that he was in a coma. I mean, that's the only thing I knew.
Mhm.
I'm not sure if you could get another lawyer or.
All right, we'll see about appointing you another attorney, all right? Just have a seat in the box and we'll go from there. And Ms. Ferguson, if you could look and see. All right, so the last time we were here, partial GPS was agreed to. That was on the 20th. And then on the 15th, we had some HIPAA release for child was granted, autopsy completed, CPS records, 911 calls needed, state to provide info on upgraded charges. So we're here to see about that.
So I do not have info on the upgraded charges at this point. The discovery, I believe, is complete. What are you still missing?
911.
The 911 call? Okay, well, I can get that easy enough. I would still like a brief period of time to get a clear answer on how our office would like to reverse.
So I'm assuming, I guess you have to go up the chain of command or something?
Yes.
All right, so this is what the court is going to do. The court is recalling this in 45 days. The court is not going to have any more resets dates for what the state is going to do. We will end up going to trial on an endangering a child, and because that's what I have before me.
Understood, Your Honor.
All right, Ms. Ferguson, I need a 45-day reset on Stevie Stokes.
March 30th.
All right, so we're going to come back on March 30th. And state provide info.
And if I have information before that, I have a pretty open communication with Mr. Piddle, so I'll let them.
All right, is there anything else?
That's it, Judge.
All right, Ms. Ferguson, we'll give you a reset form. You're excused.